and they don't, and the people who are accessing that book don't pay the original author. So how on earth do we say that public libraries are fine? We should shut them down. They should be wiped off the face of the earth.
I was thinking that you were talking about the Wikimedia.
So I would, and quite honestly, the same kind of logic would apply online as well, except that if we allow for public libraries, why don't we allow for public libraries online? I know of exactly one library that is online because under a California statute, archive.org, okay, is now described as a library. Other than that,
there's a specific statute that California passed to include archive.org.
no, that it got recognition under an existing statute as a library. But other than archive.org, I know of no other online legal libraries. Or you could think of anything on the World Wide Web because there's one copy and so many people use it as performing a library function. But why do we have the discrepancy? It's because of copyright law. Because there exists an exception in copyright law called exhaustion. Okay, so once, or the doctrine of first sale, right? So once a book has been sold, the seller of the book no longer can dictate what you can do with the book. Okay, so you can burn the book, that'll be perfectly fine. You can lend the book, that's perfectly fine. You can resell the book, that's perfectly fine. But with an electronic book, you can't do any of these things. And HarperCollins recently said that, so you have to take a license from the likes of HarperCollins if you want to do this. You can't just do it the way a library does. They don't take licenses. Okay, and HarperCollins has said for the ebooks that these libraries take from us, that license is valid only for 27 acts of lending. So you can allow your patrons to check it out 27 times. Any more times than that, you'll need to renew the license. Now this is allowed by copyright law because you can't just lend something that's electronic, technologically. Right? Every act of working with something digital is an act of copying. And what law covers that? Copyright law. So, whereas I can lend a physical book, and copyright law doesn't cover that, but with an electronic book, there's no means possible of me, doing that without copying. I can say, okay, fine, I'll copy it, I'll give it to you, I'll delete my version. Okay, but that is still copying. Okay, so it's an archaic law in many ways that is not designed to take any of the realities of the digital age into account. Yet that's what we have right now.
I have a question. If the author of the book dies, and after 60 years, it will be in public domain, no?
Yes.
So that we can use.
Yes. But the problem with that kind of reckoning of copyright law is that you need to know when the author died. So instead of just knowing when the book was published, which is often much easier to find out, okay, because it's normally there in the book itself somewhere, you need to not only know that, you need to have the research skills to find out, to go to some government office or whatever and find out when a person died, so that you can calculate from the 1st January of the next year to 60 years hence, you can do all that mathematical calculation, okay, and then know when this book is in the public domain. And unfortunately, that's that's not the easiest thing to do. So.
No, Pranesh, if I might suggest a value add for Wikipedia here. Wikipedia has very elaborate taxonomies. So when authors die, there's a date of death, and there's also all the published works. So I'm saying, in itself, Wikipedia becomes a reference for future reference material. I actually know someone, Abhay, who runs a script. I know someone who runs a script on Wikipedia that looks up Indian authors and looks up when they died and looks up their published material and then publishes the ISBNs and then tries to find digital copies and publishes them. But there's a definite value add to the taxonomies within Wikipedia, because then you can use Wikipedia as a place to find further public domain information.
Excellent point, yeah.
The Wikipedia Wikipedia connection, do you have a sense of whether the Wikipedia approach is to claim institutional copyright or author-specific copyright? Because I found references to both on the page. So what's the model? Is it a joint copyright model?
As far as I know, Wikimedia Foundation doesn't claim copyright, unlike the Free Software Foundation.
It's the copyright vests with the individual contributors. So, for example, if you print a page and you ask to include contributors, 2 pages of text and 20 pages of contributors.
One thing I want to ask is, after 60 years, we can take complete book to wiki source node actually.
Yes.
Yes, yes. So it's public domain, and unfortunately, one thing which is very important, which I should mention, and which Gautam's going to be upset with me about because I'm supposed to give him some stuff on this, is the extension of term for copyright of photographs. Okay, so right now, the minimum term that under internationally agreed treaty, the minimum term that a photograph should have is 25 years. And that's the term that Indian law has. Unfortunately, to be included in something called the WIPO Copyright Treaty, which we are not a part of right now, the Indian government is saying that we should amend our law and make it life of the photographer plus 60 years. Now, why should we be part of the WIPO Copyright Treaty? I've asked officials, they don't have an answer. We just want to be part of that. Wouldn't it be a bad thing? Because right now, in many negotiations of free trade agreements, etc., different governments want us to become part of it. And as long as we say, no, we aren't part of it, okay, we at least have a leverage. You know, you can say that tariffs on those things in Europe, you should decrease, okay, and then we'll consider this, okay. But of our own accord, we are becoming part of the WIPO Copyright Treaty, which in my opinion is a very bad idea. So, and to me, apart from being a bad idea, I just can't see any justification from it from the Indian government. And this will mean that right now you know when a photograph was published, you know when, you don't even need to know who clicked that photograph. Okay, so you know when a photograph first appeared, you can say 25 years after that, I can use it. Okay, right now under the new system, you need to know who clicked the photograph, whether that photograph is with that person or whether it is with a corporation, and when that person died. You need to know all these different, all the different things, okay, and it exists for life plus 60 years, which is a much longer term than 25. So often can add up to easily 130, 140 years.
One thing is, like, government is taking the digital copy of manuscripts now, so that is the old ones, which is not in the paper. So can we take that, if it is, even if it is copyrighted, can we take it to Wikipedia?
Now that is a question for which we don't have an answer, okay, to state the obvious. Because there are two ways of thinking about this question. One is that scanning creates a new right, okay? And the scanned image, just as the person who takes a photograph has a right in that photograph, okay, the scanned image, the person has a new right in that. I would disagree. I think that there is a possibility of arguing that the new way that copyright law has been interpreted by the Supreme Court, which is to say that just putting in effort into something, okay, and creating it, doesn't give you copyright over it. Okay, so there's a 2006 judgment of the Supreme Court that goes more along the lines that you have to have done something creative with it to get copyright.
How would you measure something creative?
Sorry?
How would you something? I mean, you measure something how it is creative, or how much it is creative.
They
There's
say
no way to measure that, right?
they say the minimum of creativity is fine. Okay, so we're not going to say that only something that say that a Sudhir Krishnaswamy produces is example of creativity. That even much, as long as it has a minimum of creativity, okay, that's copyrightable. And to give you an example of how minimal this is, in that case, the court was talking about taking a judgment, editing it a bit, adding paragraph numbers. So the dispute that went all the way to the Supreme Court of India was about paragraph numbering of something that is public, of judgments. Okay, saying that the judges themselves, when they release the text of the judgment, don't do the paragraph numbering properly. We are adding paragraph numbers, and someone else copied our paragraph numbers. Okay, and in this case, the judge said that is creative enough. Okay, but my point is, scanning might not, under the new law since 2006. Okay, because this is a remarkable shift from the law that existed earlier, which was anything which is done with the sweat of the brow. Okay, so anything into which you expend labor. Okay, so scanning takes work. Okay, it's laborious, laborious. Right? So and that would give the person who does it copyright. I believe that under the new law, as interpreted by the Supreme Court, there's a possibility of saying that is not creative enough, and that the original thing which is in the public domain, okay, is what would apply to this as well. So you can copy it.
Scanning and putting it into the web, that they will call it, say, creativity.
No, scanning it
Actually,
and
that's-
possibly
The
sorry.
best example is from the Google Books.
Yeah.
Well, that's
Issue.
often works as well.
Yeah. So actually, the rule books thing is much more complicated.
So just
So-
question, because it's an old manuscript that was
Yeah.
done definitely more than 60 years ago and by someone who died more than 60
Yeah.
years ago. The government scans it and puts the images online.
Yeah.
The question is, can you take that image and put it into Wikisource, or can you transcribe that image and put it into
No,
Wikisource?
we'll put in the wiki source and we'll transcribe in the video.
And then you, so essentially all you use the text. The image is only a reference.
No, image is also displayed, so that will not be readable. No, so if we can
Yeah.
put it in
No,
the
but
text
finally what will be used going forward is the text, right? Not the image, because only the text is editable and so on and so forth. As in, after you transcribe it,
No,
it's the
that
text.
wiki source will be automatic. We plan to keep it in a like protected manner so that no one else edits after.
No, sure. So I'm saying you have the scanned image,
Yeah.
you transcribe the text,
Yeah,
and then
we'll be putting it in one by one.
sure. But essentially, what people will use is the text
Yeah.
for to cite elsewhere.
And that's definitely allowed. Okay, so the tricky, the gray area is if you put both the image and the text. If going forward you only use the image as a reference, you don't put it up, okay, and keep only the text, okay, then that's clearly allowed. There's no dispute about that.
We want to know whether we can put that.
The image, my interpretation would be yes, but that's just my interpretation. So you have nothing better than that.
See, in general with copyright law, especially in an evolving, it's evolving in India. We've only had it 60 years. There are no clear answers to most things. So I'm not sure what our panelists would advise. One way is to say that unless we're told otherwise explicitly, we think everything is fair game. The other way is to say that unless we're told explicitly, we will use nothing. There are two extreme positions, right? But I think it's for us as a community to come up with our own idea of this. For example, if nothing can be used, we all might as well not do what we do. But on the flip side, it's very clear that we can't use everything. So I think it's more granular. Like for example, in this case, there's no, where it's a scanned copy of a manuscript, just because the government or anybody claims copyright doesn't always necessarily mean that there is copyright. So in this case, I think it's fair enough to say that it's, just the manuscript was written hundreds of years ago. Just because you scanned it doesn't mean you all have copyright. And we are not taking away anything from that. We're adding value to it. If you want, please take the transcript text and make it available on your site.
I think a lot depends on how did you access the scanned manuscript.
It's publicly available.
Publicly available under
Website.
it's the terms of use of the website. I mean that technically that is the answer to your question. What is the terms of use of the website?
It's an Indian government website. It's usable when it's up.
Just one thing in addition to what Gautam said is that I've personally seen editors in the US take on what he laid out as two ends of the spectrum, right? Take a very conservative view as well. Okay, and so saying that unless you can show clearly, okay, that it isn't that it is usable, okay, we won't allow for it. I think the community here in India can mark a departure from that also possibly, because we aren't beholden to what other editors are doing. So if collectively as a community we decide to say that this is fine, and until someone says no, actually it isn't, I don't see why that shouldn't be allowed.
And this is a discussion we've been having on the list, right? Remember the pictures of paintings in temples. I mean, now I take a picture of a painting in a 1,000-year-old temple and I upload it on Wikipedia, and the questions we've been having from Commons are, how do you know the painting is out of copyright? And everyone in India is like, the temples are 1,000 years old. I mean, what copyright are we talking about? But so we have this. The Indian community at some point needs to start evolving its own principles as well.
And I think that Wikipedia big enough to shape copyright. Right? So I think you can take some risks.
Thanks for that.
I think we
take it later after.
So I'll tell you what.
We'll take it later
so
after.
tea and
So
coffee.
we have two options now. We can either break for tea, or we can run through the next session, do our questions, and break for tea at the end. I'm tending towards doing the next session now. How does everyone feel about that?
Sure. I think break would be better than next one. It's already 2 hours.
Yeah? Okay.
Maybe 10 minutes.
10 minutes of
and
break.
then-
Alright, so can we meet back at 7:15, please?